He found that he'd repeatedly lied on a number of issues throughout the case, such that his evidence was deemed to be worthless. That, again, I think was very fatal to the claimant's case.
And he would often smirk or he would laugh. And at one point he even yelled at the Spectator's lawyer saying, "It's an unsalvageable case, Greg." He leant over the side of the stand and the judge had to say, "That's enough."
And there are many defendants to defamation cases, particularly individuals or freelancers or those that don't have the support of a well-resourced organisation behind them, who just cannot take that risk.
Hello and welcome to Coffee House Shots. I'm Michael Simmons, and today I'm joined by the Spectator's Max Jeffery and Alex Wilson, who is a partner at the legal firm RPC and the Spectator's main lawyer. Now, yesterday, a judgment was handed down in the High Court that ruled that the Spectator and our columnist Douglas Murray had won a defamation case that had been brought by the YouTuber Mohammed Hijab. Now, Max, you've been following this for the Spectator, since this began 3 years ago. Why were we taken to court?
So this was about an article that Douglas Murray wrote for the Spectator in the issue of the 24th of September 2022. And this is a long time ago, so viewers might not remember, but this was around the time that there was some unrest going on in Leicester, largely between Hindus and Muslims. And Douglas had written about this unrest in his weekly column that he does for The Spectator, and in it had referenced Mohammed Hijab, the YouTuber, going to Leicester and speaking to a crowd of mostly masked Muslim men.
Let me tell you something. All due respect, actually no due respect, yeah? If they believe in reincarnation, what a humiliation and pathetic thing for them to be reincarnated into some pathetic, weak, cowardly people like that. I'd rather be an animal.
In his column, Douglas said that Mohammed Hijab was referring to Hindu people and ridiculing them. Mohammed Hijab said that he was referring to Hindutva, which is an extremist, ethno-nationalist group of Hindus, he would say. And so Mohammed Hijab sued Douglas and The Spectator for defamation, and this has taken years and years to get to court, but it finally did, and the judgment was given yesterday saying that The Spectator had won.
And Alex, firstly, thank you for winning the case for us. It's good to have you on the podcast because it means you can do a sort of legal check while we record. But you put the case together. You were in court. Can you take us through the judgment? What did we win on?
Yeah, of course. Thanks very much. And I should say I was part of a large team. Obviously, everyone contributed very well, in particular our great barrister, Greg Callis, who presented the case in court. Well, the most straightforward defence to any defamation action is truth, and that was the main defence that we relied on in the case, and it was one that was successful. The Spectator and Douglas argued that notwithstanding the fact that the claimant may have believed or intended to be referring to the Hindutva, by criticising the other people out on the street who plainly were majority Hindu, and ridiculing them by reference to a central belief in all of Hinduism, i.e. reincarnation, he was accordingly ridiculing Hindus, and that it was the substantial truth of what Douglas had said and the sting of the defamatory statement was found to be substantially true. Although the judge actually didn't really even need to necessarily determine the truth defence, because he actually also found that the claimant's case would have failed at the first hurdle. To bring a claim in defamation in England and Wales, you need to show that a statement has caused or is likely to cause serious harm to your reputation. That's a law that's been in place since around 2013. There's been quite a lot of legal wrangling over the years as to exactly what that means, but a claimant generally now does need to demonstrate and persuade the court by way of evidence that serious harm has been caused to his reputation. And the court dismissed that aspect of the case, of Hijab's case as well. He found that the article hadn't caused serious harm to his reputation, nor was it likely to cause serious harm to his reputation. There were a number of reasons for that. One reason being the actual video of the claimant's speech in Leicester, which he himself uploaded to YouTube to his many millions of followers, was just as likely to be as reputationally damaging as what Douglas said about it. He also found the claimant's case on the supposed business opportunities that he had lost out on to have the appearance of being contrived, concocted, implausible. He found that, where in circumstances such as this, had the claimant actually suffered serious harm to his reputation, one would have expected him to be able to demonstrate that by way of evidence. And there was no evidence. There was no evidence of financial losses, no evidence of decreases in social media followers, etc. So the judge found that the case hadn't been made out. And generally, in assessing all of the evidence for the purposes of serious harm and truth, the judge found that the claimant was not a credible witness. He found that he'd repeatedly lied on a number of issues throughout the case, such that his evidence was deemed to be worthless. That, again, I think was fairly fatal to the claimant's case.
Were you surprised by, how strong the judgment was? I mean, the judge, as you just said, called him a liar.
It's a very emphatic judgment, and it's a great success for the Spectator and Douglas. And it's not all that common to get such resounding successes for media defendants in libel cases. And as the strength of the judgment does obscure the fact that there are obviously risks along the way in fighting defamation cases. There's a lot of uncertainty. No one can really ever truly predict exactly what a judge is going to do in the courtroom. You never know how witnesses are going to present, how the evidence is going to come out, how the judge is going to assess that evidence. So you never know how it's going to play out, and there's always some uncertainty. But there were many ways in which the Spectator could have won the case. They didn't necessarily have to defeat the case on serious harm and show that it was substantially true. One or the other would have worked. But it was certainly a very comprehensive victory.
And Max, you spent the 4 days of the trial actually sitting in the public gallery watching. What was it like? What was the atmosphere in the court?
It wasn't exactly electric. As you say, it was a 4-day trial, which is quite long for a case like this. And there weren't many people in the public gallery. There weren't many press there either. But it was really interesting watching the different lawyers do their work. I mean, Greg, as Alex has said, is fantastic, as is the RPC team. But it was what really kind of surprised me was what seemed to be the arrogance of Mohammed Hijab. He was there throughout the trial and sat at the back mostly, apart from when he was on the stand giving evidence. And he would often smirk or he would laugh. And at one point he even yelled at the Spectator's lawyer saying, "It's an unsalvageable case, Greg." He leant over the side of the stand and the judge had to say, "That's enough," and literally sort of to put him back in his box. And so I guess that's kind of classic, or perhaps wouldn't be surprising, given that Mohammed Hijab is a YouTuber, even he's an influencer. He's used to controversy. But I really thought that kind of sitting there throughout and watching him, that he thought that he was going to win there.
And Alex, just finally, we're at the Spectator, clearly claiming this as a vindication of the Spectator's belief in a free press, in free speech. What's the sort of legal landscape generally with regard to the press? There's been a few changes of the law in the last few years that have sort of gone against the press. But do you think that's changing? Are things getting better? Or are things getting worse?
Any victory like this for the Spectator, whereby its journalism has been vindicated, is undoubtedly, a victory for the press and free speech generally. But I think it's important to recognise that, as I mentioned earlier, there's uncertainty in any litigation. And yes, the Spectator has come to this great victory in defeating the claim, but it's had to spend a lot of money to do so, and it's had to spend a lot of money that it may not know whether it will get back in full. There is obviously always the prospect of losing a case. That means also certainly not recovering your own costs that you've incurred, but also having to pay damages to a claimant, possibly, quite significant sums if they can point to the loss of business contracts or financial losses and the like. And what are always generally even higher are the costs on the other side, the general rule being that the loser has to pay the winner's costs. So it's always a bit of a risk, and there are many, many defendants to defamation cases, particularly individuals or freelancers or those that don't have the support of a well-resourced organisation behind them, who just cannot take that risk. And you may well have heard, and people will have heard, I'm sure, of this concept of slaps, a concept very familiar amongst Europe and US for a long time, but only relatively recently coming to the fore in this jurisdiction. Now, I wouldn't describe this case necessarily as a slap. There's a hot debate about what is and isn't a slap. But, particularly where less well-resourced defendants are often sort of intimidated into caving by generally quite aggressive claimants who will, use the law of libel to their advantage, is often pretty unsavoury. But thankfully, there is a spotlight on that sort of behaviour generally. Not that I'm saying that's what was happening in this case. The serious harm threshold I mentioned was brought in 2013 to combat the perception of London, particularly being the sort of libel capital of the world. It has helped to an extent. It has, this is a threshold which the claimant did not meet in this case. Had that threshold not existed, that wouldn't have been a problem for him, and it would have really just come down to truth. That has helped to some extent, but we're still seeing, plenty of defamation cases being fought through the courts at the moment, I would say.
Thanks, Alex. Thanks, Max. And thank you for listening.